See if I'm back in here again.
You are.
And who is that on in courtroom 2?
Position
Yes,
5,
Ms.
Ms.
Dillard.
Do we know?
Position 5, Ms. Dillard. Can you hear me?
Who's in courtroom 2?
Judge, can you not hear us? Can you hear us?
Can't hear you.
We can hear you just fine.
Anybody know who that is? PD
Position
Kim.
5.
You all know who that is?
5.
PD St. Flex is there.
Yeah, I don't think she can hear us.
Can you hear me?
Yeah.
We can hear you. Can you not hear
I
us?
can't hear you all.
No.
That's crazy.
Yeah.
Can you hear me in courtroom 2?
Yes,
You
ma'am.
can? All right, Miss Dillard, that's your name?
Yes, ma'am. Yes, ma'am.
Okay. We ordered a $2,000 signature bond through the jail for your release, okay?
Yes, ma'am.
But you have to stay away from 2200 Cary Drive Southeast. Cannot go back there. Okay? You'll have to find somewhere else to stay while you're on bond, and you'd have no further contact with Rashida Cooper. And I cannot hear you, unfortunately. I may have to get on one of my other devices.
Just put thumbs up so she know.
All right, so talk to your attorney.
Miss
Do you
Dillard,
have any
you
more
cannot
questions
go
about the
back
bond?
there.
That
while
was your
she-
case, Ms. Sandflex?
Yes,
Flex.
Judge. Miss Dillard, you cannot go back there while
You'll have
she's
to talk to her.
sitting
I'll
there.
need to.
As soon as they get her out, then I can go back home.
Yeah, the eviction has to be complete. She has to be gone and her stuff has to be gone. So you don't deal with that. Have somebody else deal with that. But yes, finish the eviction.
Trying to see if I can get my
Okay.
Yes, ma'am.
All right. Thank you.
Thank you.
things back working again. Mm.
Next, if you can hear me, Your Honor, we have
Is
position.
that any
11.
different or better?
Oh, Lord.
No, still can't hear.
Position 11.
Guess we can move
1,
forward.
1, 11.
11?
Yes.
Oh,
You
sorry.
come too close to the end. Let's get through this.
She's gonna still need to hear us for our
I
last.
know this
vote
sounds
to the
crazy, but the
record.
audio worked
All
just
right.
fine in the
Mr. Rooks, can you
breakout.
hear
Should we
me?
place everybody in the breakout room and see
Yes,
if it
Your Honor,
works
I
that
can.
way?
Yeah,
Okay.
maybe that should work because we got to
We
get through
have
this.
heard your case,
Let me try to
and
call
we're
her.
going to order an evaluation for you.
It should look at her phone.
And I ordered a $2,000 surety bond in your case. And
She put me on silent.
hold on a second. Yes.
Judge,
Huh?
they're saying maybe we could do it in the breakout room so we could hear you.
Go back to the breakout.
Yes,
Put him in there too.
exactly.
Okay. All right. Thank you. God.
Took one for the team, you guys.
Thank you.
But you got a 2,000 surety. All right.
Let me get Miss Champion to put us in breakout.
Please add me to the breakout.
I need to be added to breakout also.
And who are you?
Anthony and Edwards.
Are you an attorney or because you just have Anthony on your?
Anthony Edwards. I was assaulted by one of the inmates.
What defendant is it?
I don't know his name. I don't even know him. All I know is there's a black guy with no shirt and khaki shorts on whenever it happened.
Well, hold on, sir. Miss Cheney, do you know what defendant the victim Anthony Edwards is on for?
He's for Daniels. Tavares Daniels.
Tavares Daniels?
Yeah, that one.
Okay, so you're here for Tavares Daniels. If I put you in the breakout room, you let them know that, okay?
Okay.
Wait a minute.
Okay.
Oh, he's connecting the audio now. Okay, so he's.
Okay, I'm here.
So just turn your camera back on and then we'll put you back in the breakout room.
Is it on?
Ms. Kim, can you hear me?
Yeah, we
Yeah.
can.
I can hear you.
Okay, thank you.
Working on leaving.
Okay, so which one is, yes, I can hear you. Yes. Say something, Mr. Walker.
You
Let's
can
see if
hear
I can
us?
hear you.
You can hear me?
I'm gonna get you off the cell
You
phone.
can't hear us?
No, I can't hear Mr. Walker.
Oh, no, Your Honor, you can't hear
Oh, I
us?
can hear you. Say
Oh,
something
okay.
again,
Well, there you
Mr.
go.
Walker.
Can you hear me?
Oh, now I can. What'd you
All
do?
right.
Okay. So we just
Okay,
have,
PD
can you hear
Kim
me, Judge?
I'm here, Your
and
Honor.
Miss St. Flex.
Judge, can you hear me? Can you hear me? Can you hear me, Judge?
Can you
I
hear
can't
me,
hear the
Judge?
colleague.
Okay, your phone dropped me. I have to stay on the cell phone to hear for some reason. Okay. Okay.
Okay, but the court can hear me now?
Yes.
Okay, great. It's in reference to position number 10, Mr. Nava, Gerardo. Can the court hear me? Are we ready?
Yes, I can hear you.
Mr. Nava, his accusation number is 23 CR 004900A. He's charged with harassing communications. The alleged incident date for his case is 7/26/2023. Today, during his first appearance bond hearing, there was some allegations or information about Mr. Nava's juvenile history record related to sexual charges that he was charged with, several charges that he was charged with. During this recitation of these charges, the court was in a live proceeding that was being broadcasted publicly. Additionally, the paperwork that was received for the charge this morning for harassing communications, as well as the pretrial report that the public defenders received, did not have any information that would possibly relate to, and that there were any sexual juvenile charges that would be spoken of publicly during his live hearing. As a result, we understand that this is a live hearing. It is equitable to people being present in court, and that matter has came and gone. We did object at some point, and the court did place us into a breakout room to further discuss the matter, which we appreciated from the court. But the amount of information that was put out live in public broadcast is now, once this session is completed, able to be posted and saved on YouTube and accessible to the public, thousands and millions of people. That is no longer equal to people appearing in court. Juvenile records are not accessible to the public. And so for someone to be able to pull up this YouTube live public hearing and to be able to hear the juvenile record of Mr. Nava is a violation of his rights. And they should not have access to that. It will not only affect his possible education and schooling or college or anything else where he goes to apply for a job and his name is pulled up, and then they can pull up this hearing, and then they can see juvenile records that they do not have access to for charges they do not have access to. Furthermore, for safety purposes, anybody on the road publicly, anybody who has any feelings towards someone who is accused of these types of charges, who wishes to do harm to people for these types of charges, because this is no longer will be live, this will be saved for the public, can access this recording and see the charges that they normally would not have access to. And so we are saying that the saved recording and the public posting of this recording puts the information about Mr. Nava's juvenile history in a different posture than it would be if it was just live. And now we are posting information to the public that the public is not entitled to see or have access to. And so we are requesting that the court, for that period of time in which the ASG went through the specific sexual history related to the juvenile record of Mr. Nava, silences that part of the hearing so that it is not broadcasted publicly indefinitely to thousands or possibly millions of future viewers who has access to these recordings. We do understand that the Constitution allows for public hearings, and we do believe that the live proceeding of these hearings have done that, but we do believe that public hearings and saved hearings posted on the internet are not the same in equal nature. And so we are asking for the court to take that curative nature of silencing that portion of this hearing before this is publicly posted to the YouTube page of the Fulton County Department or whichever page that it is posted on.
Your Honor, if I could
All right.
respond, please.
State.
First, I'd like to point out, well, first I'm asking that you deny the request, and these are the reasons why. First off, the defendant did not waive his presence. We do not have a waiver on file, so it's inappropriate to even have another hearing about this without him being present. Second off, the objection is not timely. Third off, under OCGA 15-11-703, juvenile records are admissible at bond hearings. This is a bond hearing, and all hearings in Fulton County are open to the public. And lastly, it's not his juvenile record that was put on the record. He's charged with statutory rape as an adult. Let's be very clear. That's not juvenile record. He is 18 years old. There was no juvenile record put on the record. He's charged as an adult. So that defeats counsel's whole argument. Oh, this is a juvenile record and shouldn't be able to be broadcasted. Well, newsflash, it's not a juvenile record. He's charged with statutory rape as an adult. He's 18 years old. And lastly, there's no legal basis. So for all those reasons, I'm asking the court to deny the request.
And I just want to be clear for the record that I thought I heard the ASG said juvenile record. And so that's a correction if I'm wrong. I thought that's what I heard.
He went to felony first appearance today. And
Well,
as of today, he's 18 years old.
I'm just saying, when the charges were read, I thought what I heard from the ASG was she said that these were juvenile charges.
I'm not showing a juvenile record. I'm showing
Okay,
that
well,
statutory.
my
rape.
argument is the same. I'm just saying that's the only reason I said juvenile.
Well, that was the whole basis of your argument, that juvenile records are not accessible to the public. It's not a juvenile record. So the argument is not the same.
Well,
and it's not founded.
well, now, either way, this is a hearing that's going to be published on
It's an open
YouTube.
hearing, correct?
And we do not believe, based on the nature of the charges, juvenile record or not, that this is something that the public should have access to permanently to go back and to be able to review for someone who is accused and charged of this. This is outside the realm of
quite frankly,
public.
that's your opinion. Your opinion is not
And
based
I'm
on
just
the law.
making the record. I'm just making the
Well, your
record.
opinion is not based on law.
I'm just making the record. It is outside of the realm and access of public access to hearings. Now we are publicly posting records on a virtual forum and submitting them to the internet indefinitely to be viewed by anyone who wants to view the case. And so if he moves forward and his case is adjudicated as a first offender and this is taken off of his record and the public is not supposed to have access to that, He's supposed to be able to say he's never been convicted of a crime. And this
Again, you're
is
wrong because
publicly,
the postings
and
only
this
last for
is
2 weeks.
publicly posted,
For 2
then
weeks.
the
2 weeks.
public will have access to what is no longer supposed to be a
Not after 2 weeks,
conviction
they will
or
not.
something that is viewable on
But
his
that
record.
would be the case for anyone in court. And when they're sentenced to first offender, their history is already read, it's already there. And then they, you know, what happens is really, you know, all of that same information is discussed and read in court. Then the court decides whether to accept their first offender plea. They do, but then they, you know, the court reporter doesn't say that I'm going to X all that out because of first offender. It's just when his criminal history is ran, when he later goes for a job after he's completed first offender, they won't be able to see it. But someone could be sitting in the courtroom, as Mr. Walker stated, and hear all of that prior to the court ruling on whether he gets first offender.
And Your Honor, we acknowledge that. We are saying the
And they could
virtual,
post and do the same thing.
the virtual nature and posting online of this is what we are saying makes the difference between somebody sitting in court, hearing it
Mhm.
live and knowing that versus it being published online indefinitely where someone has access to, where the entire public has access to indefinitely. We are saying that is the difference between people who can walk in court or look at this live. Everyone has heard it live, but when you post it online and you make it permanent online, then it turns into it's a different question and it's a different posture. And that is our only argument.
It's the responsibility of the clerk to keep.
I
records.
do understand you,
You can walk into the clerk's
but I
office and request
believe there was, it sounds like there was a mistake made by saying it was his juvenile history when it wasn't. It was his felony first appearance information. Is that correct, Mr. Walker?
That's correct.
That's
Okay.
correct. And we acknowledge that mistake, Your Honor. Again, I said, I thought what I heard from the ASG was that it was juvenile.
Mhm.
So that mistake is acknowledged on my behalf.
So if it's not his juvenile history, but it's his felony history,
Then it
that,
is, then it
Then
is
what?
the posting that we are objecting to on YouTube, this being posted virtually online indefinitely is the part that we are objecting to. Because we understand that it's not a juvenile record, so people can, it's the access. We are saying that because it's being posted and it's going to be accessible, it is outside the realm of a live public hearing where people just can go and sit and listen to something. Now that it's being published online, if he has first offender, people can go back into this saved online history and pull up this video and see that he was charged with these charges.
but
And
won't
these,
this happen on any case? And I don't mean to cut you off to be, I mean, I'm a former prosecutor myself, and I've never heard anyone make that argument because those things are always stated in open court, and people can bring their phones and still record. We don't know because they don't take the phones from him. And I don't know that that part of your argument to me makes sense, that if he gets first offender later, it will be out there in the universe. Michael, Mr. Jordan?
No, I mean, I don't understand what the whole argument is, but
the
if
issue,
we
Your
are
Honor,
arguing a procedural argument today, I don't even think that's for today's count. See, if you're talking about first offender, somebody getting first offender later on down the line, and us removing something from off a YouTube live stream, because it's right now, it's already out on YouTube.
the
If he gets first offender later,
the first offender is an example. What we are saying is this should not be published and saved online. This is not the same thing as somebody coming and sitting in court.
so then
and
that's not an
hearing.
argument for today. That sounds like something.
That is an argument for today, because once the court is over, this is going to be published online.
It's
If-
already
if
being
this is-
published
It's
online.
already,
No,
because it
it's
was live
live,
streamed.
right? It's live right now because we're still in court, but it's going to be actually saved.
So what is your argument today
in.
to say that you don't want the saved online today?
we are saying that we do not want this published online. Is
Today.
what we're saying. We don't want this that.
So that is
portion of
the judge,
recording.
Judge Macy didn't make that decision. That decision was made by our court administration. So that's what I'm saying to you. If you don't want any of these SEA hearings being broadcasted online and saved online, if you don't want any of the SAP hearings being broadcast and saved online, that is something you need to take up with administration.
We
And
are
I
just
think it should
putting
be in
our
the form of a
objection.
motion for this particular court for this. And actually, I don't know that we would have the ability to delete it or take it down later, I guess, outside of a court order, because it was live streamed,
We're just
not
putting
not
our,
saved, recorded, and uploaded for later.
but
Yeah, we
just,
have
it's
rights.
going to be saved. We're just putting our objection that we have objected to this being posted and saved online and accessed for later. We could not object to it being live streamed. That's already done. We're just saying for it to be posted, we are objecting to that portion of it being posted online for everyone to see later on. That is all we're objecting
Okay, so we
to.
take this down and his felony first appearance is still online on YouTube, so then what? They're gonna go
You
watch
said-
that.
You
We can
said
take-
what?
I'm not agreeing, but you want us to take this down, but then the felony first appearance is still on YouTube.
Yeah,
So then
it's
what?
gonna be
It's-
heard over there.
We're just objecting for our client. We're not agreeing that it should be. This shouldn't be
Oh, well,
streamed
we gonna
online
use your own
because the
objection
courts are
online.
open. We're just objecting per client. This is the client for today who's dealing with this matter, who information was given out during this hearing. So for today, we're saying that portion of this video, we are objecting to that sound portion being.
But Michael, don't
saved
you
and
have
posted.
to go back, when you go back to look at court from last week or the week before, do you have the ability to not post that, or does it go automatically?
So
Because it was recorded.
it saves automatically, but as the managers of the account, we can not post anything on YouTube that we don't want people to be.
Mhm.
Like I could go on there right now as soon as this thing save and not allow access to the video.
Mm-hmm. But I do believe it would have to be in the form of a motion to be reviewed. I don't know that I would just summarily do it, because I don't see it different from any of the other trillions of cases that I've heard since 2020, since being sworn in and starting.
And Your
this
Honor, we
hearing.
understand that
We've
we
had
can
we've
prepare
had
a
similar issues and matters and cases. I mean, Mr. Walker's aware as well, and I think we would set a terrible precedent if we, based on your oral motion, did this. It may be something that needs to be heard and addressed in a written motion. I'd like to see some statutes and law for it. I don't know, it sounds like it's a round table for the, the solicitor and the clerk and everybody else and the chief judge, because I don't know. I hear you. I understand your concern, but I think every other defendant in similar situations would have the same concern. And I don't know how you go back and do that. If he gets first offender on it, again, when he goes to apply for jobs in colleges and he completes his first offender, it won't be discoverable, and it won't be brought up in the background check. Isn't that right, Mr. Walker?
Well,
Certain
Google
employers,
did forever,
depending
so
on their
always
ability of
find-
what kind of background check they're
You
doing.
can correct, and you can always find criminal records online. So even if you take first offender, you can Google someone's name and see what they've been charged with. So I'm not sure.
And we can prepare, we understand that, Judge, we can prepare a written motion, and I'll have that conversation with my supervisor. I had it very briefly with him, and I do believe you are right as far as we need to take this up with, it's gonna be a round table type of thing. But we will look into preparing that motion. But I do want to say this last very thing, and according to what you just said.
Is your supervisor Mr. Howard? or
Mr.
someone else?
Howard, yes, Your Honor,
Okay.
and Miss Jinks. And it may not be it shouldn't be pull-upable, their record, if it's first offender. But if these things are continue to be published online the way they are, the same thing that's not supposed to be pull up, they can pull up during these video hearings or these virtual hearings online. And that's what we're saying, that's gonna be an issue. And so, but we will file a motion, if after I talk to my supervisor, if they think that that is the best course of action. We just wanted to make a note for the record.
Just to be clear,
Okay.
that's not the way first offender works. Even if you get first offender and you complete it successfully, you still have to file an additional motion to have the public record sealed.
You seal.
Or you
So-
can have it sealed at the
Right,
time of
no,
the
but even
plea.
if you get first offender, you still have to file that motion to have your record sealed. So if someone goes through the process of getting first offender and then files a motion to have it sealed, then maybe you would have a conversation. But right now, no one has taken a plea to first offender. A motion has not been filed to seal the public record. And until then, I think we're talking about the cost of tea in China.
You would
I'm
think that
trying
would
to
be on-
hear
it's not-
and
it
find
wouldn't
out if
affect
there's
you.
any prejudice or
No,
harm
nothing is
that
crime.
is coming to the defendant. And what is the prejudice or harm to this defendant versus the trillions of others? What is different about this one versus
We
any of
don't
the other
believe there's
similar
a difference,
cases that
Your
we've
Honor.
had?
We don't believe
that
there
we've
is a difference.
discussed in
We
the
just
past.
think that we haven't been addressing it, and I think we're gonna address it now. But
That's
we will
okay.
have that conversation with our
Okay.
supervisors.
Okay,
Thank
okay.
you.
all right. You're welcome. Thank you.
Okay, now that we have gotten all of that out, can we go over the calendar?
Yes, ma'am.
Thank you to each one of you.
Thanks to my cell phone, I can hear.
Once again, the reset date for the SAP calendar is going to be August the 24th. Position number 1 is reset further notice with a $1,000 SOB through the jail. Position 2, both charges were null pros. Position 3 is going to the SAP calendar with a total $3,000 good bond. Position 4, SAP calendar with a $1,000 good bond. Position 5 is reset further notice with a $2,000 SOB through the jail. Position 6, reset further notice with a total $2,000 SOB through the jail. Position 7, reset further notice with a $3,000 SOB through the jail. Position 8. Mhm. Position number 8 is reset further notice with a $4,000 SOB through pretrial per judge. Position 9 is going to the SAP calendar with a $3,000 good bond. Position 10, SAP calendar with a $20,000 good bond. Position 11 is going to the SAP calendar with a $2,000 good bond. And position number 12, reset further notice with a $3,000 SOB through the jail. Are there any comments? Maybe, let me go back. Any corrections? No comments?
You
Yes.
cannot make any
I
comments.
do have a comment. No, I'm
And
just
we
kidding. I'm
love
just
you, Miss
kidding.
St. Flex. Do not take it personal.
I'm just kidding.
Look, on that note, everybody go out and enjoy the remainder of your day.
Thank
All
you.
right, thank you. All
Bye-bye.
right, bye-bye.